Hello, Helena here from Wolfnest Property Management, coming to you today from another video with all things regarding property management. This week's topic is, should you include animals in your lease? In 2020, the U.S. Department of Housing updated rules regarding emotional support animals. Do your current policies comply with these new rules? An ESA is a pet that provides therapeutic benefits to its owner, who must have a letter from a licensed medical health professional documenting the animal's role. Including a support animal clause in your lease is an excellent way to be prepared in case a tenant requests one. It's also a great way to set some ground rules for how the support animal will behave while living in your rental property. Here are a few things to keep in mind if you consider adding a support animal clause to your lease. What are emotional support animals, first and foremost? An emotional support animal provides companionship, emotional support, or another type of help to a person with a disability. Any tenant who feels like they need an emotional support animal to cope with their living situation can get one with documentation from their healthcare provider. That includes people who are experiencing anxiety, depression, and PTSD. The Fair Housing Act is a federal law that protects people from discrimination when they're renting or buying a home. This law prohibits landlords from discriminating against tenants with disabilities. Under the Fair Housing Act, support animals are not considered pets. That means if you have a no pets policy, you may have to make an exception for emotional support animals. You cannot charge a pet fee for a support animal, and you cannot require the tenant to get insurance for the animal. However, you can require that the tenant provide documentation from a licensed mental health professional that states that the animal is necessary for their mental health. You can also require the tenant to provide proof that the animal is up to date on vaccinations. A disabled tenant must also provide the landlord or property management company with evidence that the animal has vaccinations and is free from disease, a letter or other form of documentation from a licensed health professional. Quick and easy ESA letters are available online, but you should require that your tenant get one from a licensed professional. A medical practitioner should write the document with a continuing relationship with the resident. Here's some additional considerations. If the support animal dies or is no longer needed, needs to be replaced, causes damage to the property, or is destructive, you should include it in a section in your lease to address these unexpected situations. Once you've completed the first draft of your lease, you should also consult with an attorney to assure that your clause complies with state and federal laws. An attorney can help you write comprehensive clauses for your rental agreement. They can also answer other questions you may have. Also, if you're needing help and want more insight into how you can be inclusive and avoid fair housing laws that target discrimination, contact a professional property management company such as Wolfnest, who has experience in these areas and knows exactly what to do with an emotional support animal in your rental property. Contact us today to learn more.